So participation is sine qua non to attract the criminal liability impounded under section 34. So in Barendra Kumar Ghosh, it was held that the participation is sine qua non. Sine qua non. That means mandatory. ବର୍ତ୍ତମାନ ଯେହେତୁ participation ର କଥା ଉଠିଲାଣି, because this participation is a gray area or somehow a dicey thing to discuss, that means कि participation ପାଇଁ physical presence ଦରକାର କି ଦରକାର ନାହିଁ. There is a question regarding this participation. Whether the physical presence is required or not. Physical presence of accused in the crime scene, sorry, at the crime scene. Whether the physical presence of the accused at the crime scene is required or not. ଯେମିତି ଆମେ ବରେନ୍ଦ୍ର କୁମାର ଘୋଷରେ ପଢିଲେ, ଦି ଜଣ ଗଲେ ଭିତରକୁ, ବାହାରେ ଜଣେ ଗାର୍ଡ କରୁଛି ତାଙ୍କୁ. So ତାର physically he is present near the vicinity of this crime scene. Yes or no? Now, is it mandatory that physical presence is somehow required in this case or not? I want your view on this. Anybody? Aditya?
ଦରକାର ନାହିଁ.
Not necessary.
ନା,
Why do you think so?
ଯେମିତି
Why
ଗୋଟେ
the physical presence of the...
ଯେମିତି ଆବେଟମେଣ୍ଟ ଗୋଟେ ଲୋକ କ୍ରାଇମ ସିନରେ ପ୍ରେଜେଣ୍ଟ ରହିକି ବି ଲାଇବିଲିଟି ହେଇପାରୁଛି.
liable ହେଇପାରୁଛି under which section? That is 114, right?
ହଁ
114.
ହଁ.
This is another concept. We will discuss this 114 later. But now, it is quite a dicey area. Okay, unmute yourself. It is quite a dicey area or gray area to discuss whether the physical presence near the vicinity of the crime scene is required or not. First of all, there is a case law to these effects. First one is Sri Kantaya Ramaya Munnipalli. Sri Kantaya Ramaya Munnipalli versus State of Bombay. Citation is AIR 1955 Supreme Court 287. এটি কইলা accused need to be present at the place of commission of crime. Accused need to be present at the place of commission of crime, that is near the vicinity, to attract section 34. Now in the next judgment, Supreme Court took a little liberal view, namely James Desai versus State of Bombay. Citation is AIR 1960, Supreme Court 889. What is held here is that ordinarily offenses against human body ଏଠି ଗୋଟେ କ୍ଲାସିଫିକେସନ କରିଦେଲେ ଅଫେନ୍ସ କୁ ଦି ଟାଇପ ରେ ଗୋଟେ ଏଗେନଷ୍ଟ ହ୍ୟୁମାନ ବଡି ଆଉ ଗୋଟେ ଏଗେନଷ୍ଟ ପ୍ରପର୍ଟି। ଆଉ ସେଠି କହିଲେ ଯଦି ଏଗେନଷ୍ଟ ହ୍ୟୁମାନ ବଡି ରେ ହଉଛି କିଛି ଅଫେନ୍ସ ଦେନ୍ ପ୍ରେଜେନ୍ସ ଇଜ ରିକ୍ୱାର୍ଡ। But it is if it is against property, there may be cases where presence may not be necessary. ओके तो एठी कहले जे जदि गोटे ऑफेंस होची ह्यूमन बॉडी अगेंस्ट रे तो सेठी अक्यूज्ड रो प्रेजेंस रहिबा नेसेसरी 1960 जजमेंट एटा। वर्तमान आ गोटे केस रे कहले सेम केस रे आ गोटे पॉइंट रे कहले जदि एटा गोटे प्रॉपर्टी अगेंस्ट रे होची देयर मे बी ए केस वेयर the person the presence of the accused need not be necessary, but the latest point on this topic is Suresh versus State of UP 2001 3 SCC 673। ये केस लटा ମୁଁ ଆପଣଙ୍କୁ ଦଉଛି ଖାଲି ରିଫରେନ୍ସ ପାଇଁ ନିଜେ ପଢିବା ପାଇଁ। ଏଠି କଣ ହେଇଥିବ ଦो ସୁପ୍ରିମ କୋର୍ଟ ର ଜଣେ ଜଷ୍ଟିସ ଯେତେବେଳେ ପ୍ରୋନାଉନ୍ସ କରିଥିବେ ଏଟା ଜଜମେଣ୍ଟ थॉमस जस्टिस समथिंग से जजमेंट प्रोनाउंस करथिबे सेठी कहिथिबे जे वर्तमान टाइम चेंज होउछ इलेक्ट्रॉनिक मीन्स आसिलानी जदि जने रिमोट एरिया रो रही की भी कंट्रोल करबा ପାଇଁ ଚାହୁଁଛି जदि मनी हेस्ट देखिथिबे किए प्रोफेसर हैज नेवर बीन टू एनी क्राइम सीन से फोन रे सब इंस्ट्रक्ट करे ताको टीम को से माने ऑफेंस करंती। So in that case, will he be held liable under Section 34? Will he be vicariously liable under Section 34? While addressing the same issue, Supreme Court, the justice said that with advancement of electronic equipment, if any person by binoculars give instructions through mobile phone, Section 34 can be attracted. But again, I am telling you this is not a ratio, this is not a judgment, this is merely a hypothetical view of the justice. Where another justice said that key for offenses against human body, presence must be required. So we have to wait up to the Supreme Court pronounce in his next judgment this dicey part or this gray area until it is removed. ଆମେ ସେ ପର୍ଯ୍ୟନ୍ତ ଅପେକ୍ଷା କରିବା ଯେପର୍ଯ୍ୟନ୍ତ ସୁପ୍ରିମକୋର୍ଟ ଏଇ ପଏଣ୍ଟ ଉପରେ କିଛି ରିମାର୍କ ଦେଇନାହାନ୍ତି। କିନ୍ତୁ ବର୍ତ୍ତମାନର ପୋଜିସନ ଟିଲ୍ ନାଉ ପାର୍ଟିସିପେସନକୁ ନେଇକି ଏତିକି ଯେ presence for human body it is required, but for property there may be instances where it may be required or not. It is rather a question of fact or based upon the circumstances. So to sum up, write it down. Mere presence is not sufficient under this section Rather, participation is required. Mere presence is not sufficient under this section. Rather, participation is required. Participation may be by presence or absence. Where a crime involves diverse acts to be done at different places and time, then in that case, it is not necessary that the participation must be present at the scene of crime. But where crime involves physical violence, presence is necessary. So, the participation may be direct or indirect or may be latent or patent. That means your participation, if I sum up, participation ଟା ସେତେବେଳେ required if it is involves physical violence or offense against body, participation or physical presence at the crime scene in the nearer of the vicinity is required. But if it requires, if a crime involves diverse acts, ଯଦି କିଛି diverse act କରୁଛି ଯେମିତିକି property offenses against property, money heist, professor ଯାହା କରେ ସେ ସବୁ part ରେ କରେ, ଡାଇଭର୍ସିଫାଇଡ ଆକ୍ଟ, ଗୋଟେ ଟିମ୍ କୁ ଗୋଟେ କାମ ଦେଇଥିବ, ଆସାଇନ କରିଥିବ ଗୋଟେ ଜବ ଗୋଟେ ଟାସ୍କ, ଆଉ ଗୋଟେ ଟିମ୍ କୁ ଆଉ ଗୋଟେ ଟାସ୍କ ଦେଇଥିବ, ତ ଗୋଟେ ଟିମ୍ ଆଉ ଗୋଟେ ଟିମ୍ ର କିଛି ଜାଣିନଥିବ ପ୍ଲାନ ମୋଡସ୍ ଅପରାଣ୍ଡି କଣ ଥିବ, ତ for different groups there will be different tasks and their modus operandi will also be different. So in this case, if a crime involves a diverse act, then also it is not necessary physical presence of the major crime scene will be required or not. Now this is all about the physical presence or participation, because participation of every member is sine qua non. ସମସ୍ତେ participation କରିଥିବା ଦରକାର in furtherance of their common intention. ଯଦି participation ନାହିଁ, ଜଣେ participation କରିନି, then that will not be attracted. Now ଆଉ ଗୋଟେ କଥା ଉଠେ ଏଠି, same and similar intention ଆଉ common intention. ଏ ଦିଟା distinction ହେଇଛି, କେସ୍ ଲ ସାଇଡ୍ କରିଦିଅନ୍ତୁ। ମେହବୁବ ଶାହ